appeal in the matter of UK P&I Club N.V. and another, and Republica Bolivariana De Venezuela.
Just give me a second, Mr. Lewis. Yeah, morning.
Good morning. May it please your lordships, I appear in this matter on behalf of the appellant clubs. The respondent, Republic of Venezuela, is not represented by counsel. 3 points on their representation and lack of representation by counsel. Number one, as we understand it, Cranston partners, solicitors for Venezuela, have not yet come off the record. The application to do so was made on Friday the 10th of November. As is customary, we've not seen the accompanying evidence, only the application notice itself. Last Thursday the 30th of November, Cranston partners indicated to us that the application has been sent to the presider for directions, which we assume to be a reference to the judge in charge of the commercial court list. In those circumstances, pursuant to advice from the SRA helpline, we are told Cranston partners are in attendance, but Venezuela has no counsel, and they have indicated they're unable to assist the court.
Well, they may or may not be unable to assist the court, but they're solicitors on the record, and so far as the court is concerned, I shall be asking them if they have anything to say after you have completed your submissions, and I would imagine, since they act for their clients, with or without instructions, if you make any submissions they know to be, for example, inaccurate, or they think to be inaccurate, it would be their duty to tell us. So I don't think it's possible for them to abdicate all responsibility until they have successfully come off the record. I'm not party. I don't know why they haven't successfully come off the record, although I believe it's some technical thing. But they're here. Ms. Shah, Mr. Kelly, good morning. And I'm sure you will do your duty to tell us anything you think we need to know at the appropriate stage. Is that all right? We're not taking any formal points that you're not allowed to talk in this court or anything of that kind. You can pipe up if you think you need to. Okay, good. So that's that.
2 further points on the status of representation.
Yes.
Subject to the court's guidance on what's just been said. The first is that while the court would, of course, anyway test all the arguments, it's right to draw attention to Section 1, subsection 2 of the State Immunity Act, which says a court shall give effect to state immunity even if the state does not appear. We're obviously not in that situation in extremis, but it may nonetheless be relevant. And the second point is this. Subject to your guidance, I intend to try and comply with the duty of fair presentation to bring to the court's attention the legal points in Venezuela's favour, in particular by emphasising relevant arguments and authorities in its skeleton argument.
Thank you very much. And we have the judgment of Sir Ross Cranston.
Which is in their favour.
Indeed.
On all these points. Next, I wish to provide updates in relation to the other directly related proceedings. Firstly, in relation to the 2 arbitrations which were commenced on the 14th of May 2021, as per the agreed chronology, there is a de facto stay.
When was that chronology agreed?
From recollection, subsequent to Venezuela's skeleton being filed in court. But if I may, we can check the emails, etc.
Okay, no, I don't need to know precisely, but it was in the context of the appeal, but obviously before they ceased to get instructions on the other side.
Yes, it was many months ago at least.
Yeah.
And it identifies, it's tab 5 of the core bundle, and if one is on page...
It's tab 6 of the core.
Tab 6, sorry, thank you. If one is on page 111, it identifies when it's dealing with the arbitration and court proceedings in England. In the second box, Venezuela appointed Sir Jeremy Cook as arbitrator, but very much without prejudice to their jurisdictional objections, which they take in the arbitration, just as they take jurisdictional objections here, insofar as they still can.
What
in
was
August,
the date they were started, those arbitrations?
the 14th of May 2021.
Thank you.
So that's back on page 109, penultimate row. One sees on page 114, please, that in August 2022, so after the judgment below, the parties agreed a temporary stay, but it was subject to certain conditions, namely that the arbitration agreement be varied to allow the appointment of a third and presiding arbitrator chairman rather than umpire. That's something the arbitrators had themselves proposed. And secondly, that Venezuela would take no further steps in Venezuela or Curacao.
So where are you reading?
Page 114,
Which box?
the middle main box.
Okay, thank you.
Our position is that those conditions were not complied with, but nonetheless, a de facto stay has remained the position in the arbitrations. The second set of related proceedings is in Venezuela. The clubs have not submitted to the jurisdiction of the Venezuelan court.
Sorry, just say that again. In Venezuela, what's happened? The
The
parties,
clubs have not
the clubs
submitted.
have not submitted.
The agreed chronology at page 110 records that the Venezuelan court appointed local attorneys to act on behalf of the misnamed insurers in the absence of a submission and appointment of representation by the clubs themselves. And in the next box records, as at 30th September 2021, Venezuela's position that it agreed with those attorneys a stay of the Venezuelan proceedings. The general understanding of the clubs is that service of the Venezuelan proceedings has not yet been effected on that court-appointed counsel. That may or may not be due to a previous understanding to the effect that Venezuela would not take further steps pending the outcome of these
Sorry,
proceedings.
I'm not following you. What did you say? What did you say has not been served? The Venezuelan proceedings.
The
whole thing.
On the clubs. There are obviously other defendants, and I can't speak to that. But the process, as we understand it, is that after the court appointed attorneys to act on behalf of the clubs, it would be necessary to serve the proceedings on those court appointed attorneys in their context as court appointed for the clubs, and that has not yet happened. Now, that's our general understanding. We don't know why that hasn't happened, because obviously the clubs aren't involved. It
But
may
do you
be
have contact with the attorneys appointed on behalf of the clubs?
no. So it may be that that is honouring a de facto stay, although it may also be that the court-appointed attorneys have not yet been paid. We don't know.
You have no contact with them because you choose not to, or because they're not entitled to talk to you?
We have not chosen to contact them, but we're not aware of any attempt by them to contact us.
Thank you.
Something you're worried about it being said you submitted.
Yes. So that's the Venezuelan proceedings. The third set of related proceedings are in Curacao.
Sorry to hold you up. Was there any evidence, or is there any evidence about the ability to apply for a stay in Venezuela without submitting?
There is none. Curacao. Again, the clubs have not submitted to the jurisdiction of the Curaçaoan court. The agreed chronology addresses those proceedings in particular at page 111. It records Venezuela's position that in January 22 it applied for and was granted a stay of the proceedings by way of a parking docket. The clubs have not seen any evidence of any application or order, but the general understanding is that the case has been moved to a parking docket, and so it appears in substance that it has also been stayed.
So what I'm sorry, Mr. Lewis, you're slightly dropping your voice at the end of each sentence so that I lose it. Just say that again.
It appears in substance as if the claim in Curaçao has also been stayed by way of being put into this parking docket.
Against the clubs or completely?
We think completely, but again, there is a limit to the information we have in circumstances where we have not submitted to the jurisdiction.
Yeah.
And can we take it also no evidence about the availability of a stay in Curaçao?
None that I'm aware of. Next, I wish to start, if I may, by putting the legal issues on appeal in their wider context. 3 points. 1.
These are the 3 points in your skeleton.
They are in the introductory passages. Yes, they are aspects of the judgment that are unchallenged, and therefore that set the framework for the points which are.
Okay, I'm not stopping you making them. I just wanted to know if they were the same as we'd read. Yep.
Point 1, there is and can be no challenge to paragraph 2 of the judge's order, namely the declaratory relief that the claims Venezuela has commenced in the courts of Venezuela and Curaçao are subject to London arbitration in accordance with Rule 40 of the club rules in the insurance contract. It follows, we say, that but for the fact Venezuela is a state, Sir Ross Cranston would have granted an anti-suit injunction. As he said at paragraph 77, the grounds for an anti-suit are well laid. Point 2, there is and can be no challenge to the judge's findings that Venezuela has no immunity from the jurisdiction of this court for 2 reasons. A, its actions in pursuing the claims in Venezuela and Curaçao are commercial activity for the purposes of section 3.1a SIA.
When you say no immunity, you mean no adjudicatory immunity?
Yes. And the judge makes that clear in paragraph 84. Those proceedings involve nothing more than what a non-sovereign would do in undertaking legal proceedings of this character. The claims seek to enforce an insurance liability for losses which have occurred. Point B, Venezuela is to be regarded as bound by the arbitration agreement within section 9 of the State Immunity Act. That is judgment, paragraph 87. The third point of context is this. We say there is also and can be no challenge to the judge's finding that Article 6.1 of the European Convention is engaged. That's paragraph 97 of the judgment. That means section 13.2a, State Immunity Act, is a violation of the club's rights. The issue on grounds 1 to 3 is whether that violation can be justified as pursuing a legitimate aim by proportionate means.
I mean, do we talk about violations of Article 6? Do we not talk about an infringement of the principle which may or may not be justified? I mean, it's not an absolute right. It's not Article 2.
The word violation is not mine, but I don't want to dwell on whether it's different from infringement. I say it won't affect the issues we come on to in a moment. Grounds 1 to 3 ask whether violation or infringement of the Article 6.1 rights can be justified.
Yeah. In the Article 10 context, it's usually referred to as an interference, which one then looks at justification for. That may be a happier.
I mean, this court has done quite a bit on Article 6 lately. You'll probably have seen my judgment in Churchill last week, which was all about infringement of Article 6 and applying exactly the principles that I think apply here, which is that you have to make sure that the infringement is proportionate, pursues a legitimate aim, is proportionate to that legitimate aim, and doesn't interfere with the substance of the right, or whatever the words are.
I should say I haven't read that judgment, so
maybe you should.
I should have done. I haven't, but so I don't want the court to think that I have. And if at any stage the court wants me to speed up because of
I mean, the other
judgments.
judgment that is important is the judgment of the Supreme Court last week in the case of local authority against persons unknown, which validates a new approach to injunctions previously held in a case called Convoy Collateral. So that's also something that one might look at.
Well, we have the benefit of this case being split across half days, and so we will
You've got plenty of time in the
endeavour
morning
to look at
catch up, Mr. Lewis. Yes.
all of that material, for which I'm very grateful.
Mr. Thompson is licking his lips.
In that context, I turn to ground of appeal 1. It relates to the test or tests for identifying when infringement of Article 6.1 can be justified on grounds of customary international law. And we say for that, the principle is correctly stated in the Prestige number 3, which we have in the authority bundle number 2, tab 22, starting at page 765. The Prestige broke in two off the Spanish coast, causing significant pollution. Spain and France brought claims in Spain, whereas the P&I Club civil liability insurers advanced arbitrations and claims in England. The relationship between Article 6 and customary international law was considered at page 788. At paragraph 39 on page 788, the court explained the restrictive theory or restrictive doctrine of state immunity distinguishing between private acts and sovereign acts. And then for today we say paragraph 40 encapsulates the key point, and we do say the answer on ground of appeal 1. The judgment explains how, in the converse situation, however, in which there would be no immunity under customary international law, there is a more direct correlation between immunity under customary international law.
Where are you reading?
Paragraph 40, please, at the bottom of page 788.
In the converse situation to what?
In the converse situation to what's been explained above as arising from ALCOM, namely that where there is a correlation between pre-existing customary international law and what happens in the State Immunity Act, it is unlikely that the Act was intended to depart from what went before. And
in other words, where there is a unity between a principle of customary international law and what's to be found in the 1978 Act.
Exactly so.
That's what paragraph 39 deals with.
Yes. And then paragraph 40 comes on to the converse situation.
Yes.
And the key sentence for us is at the top of page 789, where the judgment says, as explained in Benkabush, any immunity granted to a state is necessarily incompatible with Article 6 as disproportionate if and to the extent that it grants to a state an immunity which would not be afforded in accordance with customary international law. We say that is a correct reading of Benkabush.
But that's not everything Benkabush says.
No, and we're going to come on to it, but we...
But before we get there, obviously this is a judgment to which my Lord Justice Phillips and I were party. And if one starts at paragraph 40 with the converse situation, the converse situation is where there is a conflict between customary international law and what is stated in the Act. And we have to be careful, don't we, in the context of our case today, to distinguish between circumstances in which there is a rule of customary international law which provides positively that there shall be no immunity in a particular situation, and circumstances where there is no rule of customary international law pointing in either direction. Now, what was said here about the converse situation in which there would be no immunity under customary international law may be read as saying, to put it at its lowest, that we're dealing with the situation where customary international law positively provides that there should be no immunity, which is the case with adjudicatory immunity under the restrictive doctrine. And if it is to be read in that way, then this doesn't really take you any further, does it?
Well, if it only goes that far, no, it doesn't. And we say it encapsulates both situations, but I'll have to come on to make that good by reference to Benkabush, I accept. But what we do say is that where there is the Article 6 right, then both in circumstances where one has overstepped the existing rule, but also in circumstances where customary international law does not mandate an immunity because the area has not yet been touched, as it were, then also Article 6 requires the forum state not to go further.
I understand that's your case. The distinction I was making isn't a distinction that mattered for the purposes of this case, Prestige 3 and 4, is it?
It isn't, and we don't say this is ratio. We just say it's a neat encapsulation of our case on ground 1 and a correct reading. And we do say that the logic is unimpeachable and applies equally to both of those two situations we just discussed. And that's because one has to ask, what is the legitimate aim here to justify the interference? And the legitimate aim is compliance with customary international law. It's not choosing from a menu of possible customary international law solutions that may or may not arise at a later date. It's compliance. And that's why those two situations fall to be dealt with.
Well, that's not what Sir Ross Cranston said about the legitimate aim, is it? He said the legitimate aim was sovereign international comity.
What, he did. He decided the case against us on two separate bases, which are reflected in grounds 2 and 3, respectively. So, firstly, he decided, as reflected in ground 1, he decided that the test has a fallback category, and that's what we're going to look at in Benka-Bush terms. And then on ground 2, he decided that on that basis, because the UK was not alone in having a provision like Section 13(2)A, then that was good enough in terms of customary international law as the justification. But then separately, in terms of domestic policy, he then relied on comity specifically. And so we do say one has to take each of those points in stages.
But in relation to the first of them, I think really the difference between you is that where there is a rule of customary international law, then no dispute the justification has to be to give effect to the rule. But where there is no rule of customary international law, Sir Ross Cranston's view, based on Fogarty and his reading of Benka-Bush, was that the justification could arise in compliance with accepted international standards, those being something which hadn't yet crystallised into a degree of consensus so as to amount to a rule of customary international law. And that's really the issue on ground 1, isn't it?
That's the issue on ground 1, whether there is that secondary category which can justify the infringement. And we say, on a proper reading of Benka-Bush, there isn't. We accept that, and I shouldn't put that as absolutely, we accept that there is a fallback category, but it's not as permissive as the judge and Venezuela would say. So we say it is, as per the Court of Appeal decision, which we're about to look at first to understand Benka-Bush properly,
it's tenable view of a rule of customary international law.
Yes, obligations under customary international law. And that's the key point. It's all part of what the Court of Appeal call a single test, because it's all in a context where we're saying that the legitimate aim is compliance with customary international law. And so we comply either because the rule is clear and we're bound to comply with the clear rule, or we comply because we reach a tenable view of what the obligation is, but not a further, more diluted category where we
not Fogarty.
Not Fogarty. Well, Fogarty also needs to be properly understood, and we'll come back to that, but not a more permissive front-running of customary international law, and that's the point. Can one say, with a few other states that are like-minded, we're going to trailblaze and pick from a menu of what are possible customary international law solutions, and we have a degree of safety in numbers, provided we're not alone. And that's what we say is off-limits.
What about the respondent's notice? What's your position as regards its status, given that Venezuela are not here to argue it?
I was going to deal with it on the basis that my duty to make a fair presentation required me to address it. If the court, of its own motion, doesn't want the respondent's notice to be in play, then that's a matter for the court. But I was going to address it.
Well, let's see, shall we?
So we do ask, please, that one start with the Court of Appeal in Benka-Bush, and that we find in the second authorities bundle at tab 16, page 0507 of the electronic.
Sorry, I just what page in the electronic authorities?
0507.
0507?
Yes,
Or just
507.
507. Why do we have a 0? Okay, got it. Bengabush in the Court of Appeal.
Thank you.
Overruled.
Well,
The appeal was allowed, was it not?
yes, but on this point, it's no. The appeals were dismissed. Sorry.
Were they? Okay, good.
So Fatima Benkabush and Mina Jana were employed at the Sudanese and Libyan embassies in London respectively, but both brought unfair dismissal claims and were met with assertions of state immunity under the State Immunity Act. The issue was whether the provisions of state immunity in the Act relied upon by the states could be justified by reference to international law and so were compatible with Article 6.1. And both the Court of Appeal and Supreme Court held they were not so justified, but for reasons that do not appear to be the same. So if one picks this up, please.
So which reasons do we take? Their reasons were different.
The Supreme Court reasons,
Yeah.
but understood in the context of the Court of Appeal reasons and what was being argued by the Secretary of State on the appeal in the Supreme Court. And we do say that's important in circumstances where what is said at paragraph 36 in the Supreme Court is not clear. We're arguing about what it means.
So you say 36 is not clear in the Supreme Court.
I do, and we'll come back to that. If we pick this up, please, at page 525, paragraph 17. The judgment of the court says here that the Strasbourg jurisprudence, and that's on the relationship between Article 6 and international law, identifies the legitimate aim, i.e. the legitimate aim to justify an infringement of Article 6 as compliance with international law. And it goes on at paragraph 17 to say in the fifth line that the legitimate aim is described in identical terms in Fogarty. At paragraph 18, the approach of the Strasbourg Court to proportionality appears from its judgment in the Al-Adzani case. And this is the statement that one sees repeated over and over by the European Court. Measures taken by a high contracting party which reflect generally recognised rules of public international law on state immunity cannot, in principle, be regarded as imposing a disproportionate restriction on the right of access to court as embodied in Article 6.1. They then explain how that's repeated in the more specific context of embassy employment disputes in the Fogarty case. And then at paragraph 19, the court refers to a key debate before it, which is echoed here in Venezuela's reliance on Fogarty. So they say the observations of the Strasbourg Court in Jones and United Kingdom were the focus of a great deal of argument during the submissions before us. At paragraph 189, the court repeated the proposition that measures which reflect generally recognised rules of public international law on state immunity cannot in principle be recognised as imposing a disproportionate restriction. However, in the following section of the judgment, under the heading Application of the Principles in Previous State Immunity Cases, the court said at paragraph 190, and then there is a citation from Jones, and if one sees in the middle of that, next to letter C, the court had said, in particular, the court examined whether the respondent state's actions fell outside any currently accepted international standards. That's Fogarty, paragraph 37, the key paragraph for today. So what is made of that is at paragraph 20. And this is important, we say, because it shows how the court reconciled the general statement of principle taken from Al-Adzani with other dicta, such as paragraph 37 of Fogarty, that suggest a softer-edged approach. So on behalf of Libya, Mr. Landau had submitted that this passage, that's above, and in particular the different formulations, i.e. or e.g. Fogarty, paragraph 37, introduce a measure of flexibility into the test of proportionality. However, it seems to us that although it may be formulated in different ways, we are here concerned with essentially one test, which is whether the grant of immunity is required by international law. In our view, this follows from the fact that the legitimate aim at which these means are directed is compliance with international law. Despite the different formulations, it seems to us that if a state adopts a rule restricting access to the court, which it is not required by international law to adopt, there is a violation of Article 6 of the ECHR, unless the rule otherwise meets the requirements for a limitation on that right. And here's the reconciliation of the different statements of the European Court. In this regard, we also note that the formulation in para 189 appears in a section headed General Principles on Access to Court in the context of state immunity, whereas the passage at 190, that's covering the different formulations and Fogarty 37, appears under the heading Application of the Principles in previous state immunity cases. We do not read these formulations as intended to detract in any way from the statement of principle at para 189. And then paragraph 21 goes on to explain, nevertheless, this does not mean that the application of the proportionality test is totally inflexible. Turning on to the next page, at the end of paragraph 21, the court makes a point that Venezuela would, if here, probably rely upon, or if represented by counsel, probably rely upon. So I draw to your attention. It starts just below letter C with the word accordingly. And perhaps I could leave your lordships to read the balance of that paragraph. So what Venezuela say is that it's necessary to have and to understand the margin of appreciation to enable states to be forerunners, not the European Court, but states to be forerunners in areas where customary international law is not yet established. And what we say is that one has to re-emphasize that the final sentence reflects that the margin of appreciation is in determining obligations.
Well, that's not concerned with being a forerunner or situations where there is no obligation either way under international law. It's concerned, that last sentence, in the margin of appreciation in determining what those obligations are.
We don't accept that there's a distinction between determining the extent of obligations that everyone agrees to exist on the one hand, and determining whether there are obligations at all on the other hand. In either case, one is asking, what does compliance require here?
Yes, but it's not concerned, is it, that the margin of appreciation that's there being talked about is not concerned with being a forerunner where there is no obligation. Customary international law is quite a narrow concept in terms of the degree of universality that it requires. There are lots of international practices which may be quite widely followed, but have not yet attained the status of customary international law. And your case, I think, is that those international practices simply can have no bearing on the justification of exercise that we're concerned with, unless and until they've crystallized into a rule of customary international law.
That is our primary position. We also say under ground 2 that the restrictive doctrine covers injunctions. So if I'm wrong on ground 1, all is not lost.
And when we're concerned with your submission about whether you can be a forerunner, because one knows in the real world that there's a point of quite universal practice before it becomes a rule of customary international law, the situation that is engaging with doesn't involve a rule of customary international law at all. So that we're not dealing with a margin of appreciation in determining what the obligations are by reference to a concept as to whether someone can be a forerunner or not. That's the difficulty I was having with your submission.
Well, what we do say is that there is no difference. We accept the summary, which is that practices emerge and that they don't necessarily crystallise quickly into the substantial uniformity required for a rule of customary international law. But what we do say then is that the 46 Council of Europe members have curtailed their ability to make a discretionary choice that either because an existing rule does not go as far as they think it should do, and they want to forerun in extending it, or because in an area where there currently isn't a rule, they think there should be a rule, they want to take steps to create that rule and start the ball rolling towards a critical mass that will develop substantial uniformity. And we say in both situations, one is not dealing with compliance with international law.
Well, what about finishing the ball rolling? Suppose that it isn't a rule of customary international law simply because the bloc of 46 states is the outlier. But the bloc of 46 states universally wants to fall in line in order to make it a rule of customary international law. Your case is that they can't do so.
They can, by way of treaty. That they can't, and collectively, but they can't, one of them can't do that.
Well, I thought we were looking at what the Court of Appeal said in Ben-Kabouche.
Yes, and so paragraph 22, they say that, and I do say this is slightly contrary to what my Lord Justice Popplewell was just saying about how there's a difference of principle between determining the outer limits of an existing rule on the one hand as against determining what the rule might be where there isn't currently any rule. Because what the Court of Appeal says is that last part of paragraph 21 is reflected in Fogarty, paragraph 37. So they segue straight into exactly the point I am saying still has to be assessed by reference to obligations under international law. And then over the page of paragraph 23, having quoted Fogarty, they said that the approach was also apparent in the submission on behalf of the UK in Jones that there was a margin of appreciation as regards access to court, which permits states to act on their own views as to the extent of their obligations under public international law, provided they are reasonably tenable views. Although the Strasbourg Court did not expressly rule on this submission, it reiterated its previous statements that states enjoy a margin of appreciation. So we don't accept that there are two different margins of appreciation here. One at the fringes of an existing rule and one dealing with the vacuum where there is no rule. We say it's a single margin that begs the question as to the extent of obligation. And then paragraph 24, the court says the extract from Fogarty set out above shows the court granting a wide margin of appreciation. And then at paragraph 25, they explain how later cases have taken a rather different view of the scope of the immunity. And then they deal with various subsequent cases through 25 to 28. And one can then please move on to paragraph 46 on page 541, which is where they apply the test. And they say there can be no doubt that Libya is correct in its submission that state practice in relation to immunity from employment claims by members of a diplomatic mission is diverse. We find it impossible to conclude that there is any rule of international law which requires the grant of immunity. And then in the last 6 lines or so, they say, furthermore, the preponderance of state practice is such that whatever the position may have been in 1978, the position contended for by Libya and the Secretary of State can no longer be regarded as within the range of tenable views of what is required by international law. So the margin is there, we say, clearly focusing, having put Fogarty in that context, on what is required by international law. It's back to the one test that was introduced by this court at paragraph 20. And the margin of appreciation, and we say Fogarty, paragraph 37, go to flexibility being required where there are doubts as to precisely what the extent of the obligation is. Paragraph 53 on page 543 reiterates the test being applied. A rule of the breadth of section 16(1)(a) is not required by international law.
So which paragraph are you on now?
53 on page 543. And the emphasis is upon it not being required by international law or within the range of tenable views of what is required by international law. And paragraph 65, final sentence on page 549, is to the same effect. Its focus is upon obligations. So pausing there before we jump into the Supreme Court decision, we do say that if one had only the clear-cut Court of Appeal guidance from Benkabush, the test under ground of appeal 1 would be clear and there would be no question of Venezuela showing that section 13(2)(a) was mandated by customary international law or took a reasonably tenable view of the UK's obligations under customary international law. So that is why the context for the Supreme Court decision is whether it made it easier to justify an infringement of Article 6.1, in particular by reference to the margin of appreciation. If we can start then, please, at page 585. Here we are in the submissions of the Secretary of State. And in the paragraph next to letter D, the Secretary of State argued this: as to the threshold, the clear and constant jurisprudence of the European Court provides that measures taken by a high contracting party which reflect rather than require generally recognised rules of public international law cannot be regarded as imposing a disproportionate restriction on the right of access to court. Applying that formulation, it is manifestly not necessary to identify a specific obligation in international law. The test is more open-textured. And see what's relied upon there? Jones in United Kingdom, paragraph 190. So that's where we looked at the wider formulations on which Mr. Landau had relied in the Court of Appeal when saying it's open-textured, and which had been dealt with in the way we looked at by the Court of Appeal. The submission is that the Court of Appeal have put the test too highly. It's unnecessary to identify a specific obligation. One has a more permissive margin of appreciation. And see also, please, the submission in the short paragraph next to letter H. A state which acts within the parameters set by international law is acting in a way which reflects generally accepted principles of international law, even if it would be possible within those parameters to take an alternative view. The possibility that more than one view may properly be said to reflect those principles arises because there are grey areas where state practice is diverse and customary international law has not yet crystallised. So it's similar to the discussion we had a few moments ago. If one then turns, please, to the judgment. If we can start on page 594, paragraph 8. I just note this in passing so we don't have to come back to it on ground 2. Before 1978, state immunity was governed in the UK by the common law. Properly speaking, it comprised two immunities whose boundaries were not necessarily the same: an immunity from the adjudicative jurisdiction of the courts of the forum, and a distinct immunity from process against its property in the forum state. And over the page on 595, that is said to have been developed specifically in the Philippine Admiral case and the Trend Tex case. If one turns then, please, to page 600, at paragraph 20, Lord Sumption identifies how the Strasbourg Court has dealt with many cases involving claims to state immunity, and in the final sentence of that paragraph, he says, the only cases in which it has ever held Article 6 to have been violated are those in which it has found that a claim to state immunity was unfounded in international law. So that begs the question of what is required to found a claim in international law. And then at paragraph 21, it says it is convenient to start with 3 judgments delivered on the same day by a similarly constituted Grand Chamber, and that's Aladzani, Mechelini, and Fogarty. At paragraph 22, Lord Sumption.
Sorry, just to go back to the last sentence of paragraph 20, forgive me. Unfounded might mean contrary to, or might mean has no support in. But is it in fact the case that the only cases in which the Strasbourg jurisprudence has ever held Article 6 to have been violated are those in which it's found that a claim to state immunity was contrary to international law?
I will have, since the answer to that question depends upon a panorama, I will get back to your lordship as soon as I can. It is convenient to start with the three judgments. They're rendered on the same day, which we say makes it unlikely they were intended to say substantially different things. One has Alazzani cited, and over the page one sees paragraph 56 thereof embedded, which has the principle we've already seen and which is being relied upon by the Secretary of State here, particularly for the use of the word reflect, juxtaposed with the word required. Paragraph 24 then recounts Fogarty, and Venezuela rely upon that paragraph in particular and would emphasise it if here by counsel. It quotes from paragraph 37, which is the paragraph relied upon by the judge and Venezuela. And then at the end of the paragraph, as Venezuela again relied upon, says, these observations are consistent with the view that in the absence of a recognised rule of international law, Article 6 is satisfied if the rule applied by a convention state lies within the range of possible rules consistent with current international standards. And that is key to Venezuela's case, because they say there is the dichotomy my Lord Justice Popplewell has been setting out, namely there are two scenarios, A, where there is a recognised rule, and B, where there is no recognised rule. Like the Court of Appeal, Lord Sumption goes on to refer to various other state immunity cases in the European Court, Kudak and Sabe, and we can pick up again, please, at page 606. Paragraph 31 is relied upon by Venezuela. It's a point that has already been taken, namely that there is a relatively high threshold to establish a rule of customary international law, namely substantial uniformity. And then one turns, please, to page 607. And here one starts with the heading. Lord Sumption entitles this section of the judgment, "The Margin of Appreciation, a Tenable View." And he then sets out the Secretary of State's submission on margin of appreciation, including as applied to the facts of the case. So the Secretary of State's case is that there is no sufficient consensus on the application of state immunity to a contract for the employment of non-diplomatic staff. He submits that two consequences follow, and we'll need to divide those two up carefully. The first is that Article 6 is satisfied if the rule of the forum state reflects generally recognised principles of international law. For that purpose, it is enough for the forum state to apply a tenable view of what international law is, or at any rate, that its domestic law applies a solution that is not outside the currently accepted international standards treated as a benchmark in Fogarty. So we say that the Secretary of State's submission was actually put in three ways, which we've broken down in paragraph 29.1 of our skeleton. And as we've just seen, the Court of Appeal had accepted the first two propositions, but not the third, and its further permissive margin of appreciation. Back to paragraph 33, Lord Sumption says, he submits it is not necessary to show that international law requires the foreign state to be treated as immune. The second consequence is said to be that in the absence of a rule of customary international law justifying some other solution, the state employer is entitled to absolute immunity. This is because in the Secretary of State's submission, the restrictive doctrine of state immunity operates by grafting exceptions onto the principle of absolute immunity, so that unless until a relevant exception has achieved the status of customary international law, the immunity remains unqualified. And we will come back to the second consequence and submission in a moment. But on the first one, that is addressed at paragraphs 34 to 36. So at paragraph 34, Lord Sumption says he can deal quite shortly with the suggested distinction between reflects and requires, for in my opinion, it is misconceived. The argument is based on al-Adzani and the use of that word reflect. To give rise to the margin of appreciation, as repeated in most of the subsequent cases. See Fogarty. Over the page, Lord Sumption says, but in my view, the distinction proposed by the Secretary of State is a purely semantic one. International law is relevant to the operation of Article 6 because in accordance with Article 31(3)(c) of the Vienna Convention on the Law of the Treaties, the Human Rights Convention is interpreted in the light of any relevant rules of international law applicable in the relations between the parties. It is therefore necessary to ask what is the relevant rule of international law by reference to which Article 6 must be interpreted. The relevant rule is that if the foreign state is immune, the forum state is not just entitled but bound to give effect to that immunity. If the foreign state is not immune, there is no relevant rule of international law at all. And that's the relevant rule of international law by reference to which one construes Article 6. And we say that's the point that's been neatly summarised in the Prestige number 3. What's important is the explanation that is then given for why this is the binary position, we say, in terms of customary international law obligations. What justifies the denial of access to a court, so the infringement of Article 6, is the international law obligation of the forum state to give effect to a justified assertion of immunity. A mere liberty to treat the foreign state as immune could not have that effect, because in that case the denial of access would be a discretionary choice on the part of the forum state. To put the same point another way, if the legitimate purpose said to justify denying access to a court is compliance with international law, anything that goes further in that direction than international law requires is necessarily disproportionate. I conclude that unless international law requires the UK to treat Libya and Sudan as immune as regards the claims of Ms. Jana and Ms. Benkabouche, the denial to them of access to the courts to adjudicate on their claim violates Article 6. Paragraph 35 then says there are circumstances in which an English court considering the international law obligation of the UK may properly limit itself to asking whether the UK has acted on a tenable view of those obligations. And various examples are then given of what might be considered politically sensitive scenarios. But over the page, Lord Sumption says, I decline to treat these examples as pointing to a more general rule that the English court should not determine the points of customary international law, but only the tenability of some particular view about them. It is necessary to decide a point of international law in order to resolve a justiciable issue, and there is an ascertainable answer. Then the court is bound to supply that answer. We then have paragraph 36, which is the cornerstone of Venezuela's case, saying that there has been a dilution of the position as compared to the Court of Appeal. And before we read it, we do say it is obiter. Lord Sumption did find there to be a relevant rule in this case, namely the restrictive doctrine. And given that this is an obiter paragraph, we say this may be a situation where the court doesn't need to focus too extensively on what Lord Sumption meant. But we say as follows about paragraph 36, and perhaps...
Well, this is all obiter, isn't it, so far as the case with which we're concerned, because this was a case in which, we can see from the bottom of 37, there was a rule of customary international law, and the rule was that you do not have immunity, adjudicatory immunity, for non-sovereign acts. The issue for us to decide is whether that applies where there's no rule either way of customary international law. So in a sense, everything that Lord Sumption's saying in this case is obiter from that point of view.
Well, we say paragraph 34 was ratio of the decision on that case. But yes, beyond that, we agree that it's obiter. And your Lordships will have read it already, but if I just emphasise this from paragraph 36, it refers to paragraph 37 of Fogarty and the Trend, and says, in those circumstances, the Strasbourg court thought it sufficient that the UK had acted on a view of international law, and we say that a view of international law, which, although not the only possible one, was within currently accepted international standards. But this is not the same point as the one made by the Secretary of State, for it applies only if there is no relevant and identifiable rule of international law. If there is such a rule, the court must identify it and determine whether it justifies the application of state immunity. He then refers to Kudak and Sabah El-Lail, and then says in the final sentence, for reasons which I shall explain, I find the view expressed in Fogarty that there was no relevant and identifiable rule of international law surprising, but that is another matter. So we say as follows about paragraph 36 of Benkovic. Lord Sumption starts by saying...
So what did you say about 36? You say what follows?
We say as follows, and I'm about to set
sorry.
out. Sorry. Lord Sumption starts by saying Fogarty does not say anything very different. And we say it would be surprising if that paragraph then actually went on to add the margin of appreciation, in particular by way of a fallback category that has just been rejected, we say, as insufficient. If it adds anything, paragraph 36 only applies if two conditions are fulfilled, which substantially narrow its scope so as to be nearly non-existent. And the first condition is this: there is no relevant and identifiable rule of international law in accordance with which the court can test compliance. We say the absence of any relevant rule will be rare indeed, given the prevalence of the restrictive doctrine. Second condition, nonetheless, the state has acted in accordance with a tenable view of international law. And Lord Sumption uses that phrase, on a view of international law. And we say that must mean a view of what international law requires. That is, in substance similar to the clear position in the Court of Appeal as to the margin of appreciation. In circumstances where the court is practically bound to decide what is the relevant rule of international law, and that's paragraph 35 above, either the first condition will not be satisfied or the second condition will fall away, because either one will identify the relevant rule or there won't be a tenable view of the relevant rule, the relevant international law that creates the obligation. And what we do say is that it would wholly undermine the ratio of Benker-Bush at paragraphs 33 to 35 if a state could say, even though we can't justify this immunity by reference to a binding rule of customary international law or a tenable view that we have an obligation under customary international law, we think our position is reasonable because it's shared by a few others. So those textual points and contextual points on the judgment are the platform for the submissions we make in the skeleton starting at paragraph 33. So first, one has to start with the question, what is the legitimate objective? And in terms of customary international law, it is compliance. And that begs the question of compliance with what? Now, we do have to come back to comity when we get to domestic policy objectives. But grounds 1 and 2 are dealing with customary international law. The second point we make at paragraph 34, we do say that there's an incoherence on the judge's approach and also that of Lord Sumption if he's interpreted in the way that Venezuela say, i.e. to endorse a proposition that a state can choose from a menu of possible non-binding options in the absence of an identifiable and relevant rule. If, as per paragraph 34 of Lord Sumption, the legitimate aim is compliance and one cannot overshoot when there is an identifiable rule, it's hard to square that with it being permissible to overshoot when there is no identifiable rule. The legitimate aim at which one is shooting is compliance. And the reconciliation, we do say, lies in understanding that Lord Sumption is not endorsing the idea that Fogarty allows choosing from a menu of possible non-binding rules. It would bring back the margin of appreciation to what the Court of Appeal had rejected. And that's why we say when Lord Sumption at paragraph 36 refers to a view of international law, it should be interpreted to mean a view of what international law is, not what it might later become after crystallization of substantial uniformity. Our third point at paragraph 35, we do say that the obiter dicta are far from a ringing endorsement of Fogarty, only saying it does not say anything very different. On Venezuela's case, it says something very different by setting up an alternative test. The fourth point at paragraph 36, we say it's highly improbable that in rejecting the Secretary of State's submission, that the Court of Appeal had set the threshold too high. That's why I've gone through these stages. Court of Appeal sets a clear threshold with the only fallback tenable view of what the obligation is. Secretary of State says that's too high a threshold, and Secretary of State's submission, first consequence, is rejected, and yet Venezuela say the threshold is set lower. Venezuela, if hereby counsel, would say it's just a different point. Lord Sumption created a dichotomy depending upon whether there is a relevant and identifiable rule of customary international law. If that is right, then the Court of Appeal, at least, would have been obliged to reach an alternative result, because they found, unlike Lord Sumption, that there was no relevant rule of customary international law. The fifth point, paragraph 37, and we do say, if Venezuela's interpretation is correct, it creates an irreconcilable tension between the different passages in Lord Sumption's judgment. The sixth point, paragraph 38, we say the European Court has moved on. Both the Court of Appeal and the Supreme Court identified how they'd moved on from Fogarty. Paragraph 37 of Fogarty, i.e. the application to the facts in that case, we say, does not get recited in any subsequent European Court decision, and that we have checked. What gets recited over and over is the Alazzani principle, paragraph 56. So keeping Benkabush open, if it's convenient, I do want to divert briefly to two European Court cases here, and the first is Fogarty itself. And we say that the key paragraph 37 relied upon there is also obiter. So for that, please, it's Authorities Bundle 3, tab 30, page 1069. The applicant had complained of discrimination in the refusal to re-employ her in one of two posts at the US Embassy in London. The UK successfully relied on state immunity, and the UK provisions were upheld. At 1081, please, one has the relevant paragraphs. Starting with paragraph 36, this recites the general principle that was in Alazzani on the same day that one sees repeated over and over.
Sorry, 36 on page 1081.
Yes. And then paragraph 37 deals with diversity of state practice in relation to employment-related disputes at embassies generally. So the court observes that on the material before it there appears to be a trend in international and comparative law towards limiting state immunity in respect of employment-related disputes. However, where the proceedings relate to employment in a foreign mission or embassy, international practice is divided. And then one has the key passage on which Venezuela relies. Certainly, it cannot be said that the UK is alone in holding that immunity attaches to suit by employees at diplomatic missions, or that in affording such immunity, the UK falls outside any currently accepted international standards. But we do say that point is obiter because the key point comes in paragraph 38. The court further observes that the proceedings which the applicant wished to bring did not concern the contractual rights of a current embassy employee, but is instead related to alleged discrimination in the recruitment process. So the employee had previously worked at the US Embassy, but the facts were about a claim for discrimination in refusal to re-employ her in one of two posts. And what the court says on that is that the court is not aware of any trend in international law towards a relaxation of the rule of state immunity as regards issues of recruitment to foreign missions. So on recruitment, international law is clear and in the UK's favour, and that's what's decisive. One has been introduced to that decisive point by the wider question in relation to employment-related disputes generally for embassy employees. And it's based on 38, the court then goes on to say at 39, in these circumstances the court considers that in the present case the UK cannot be said to have exceeded the margin of appreciation. So the position in relation to employment-related disputes generally was not the decisive point. The second case to show...
It may not matter very much because we're not looking through the lens of stare decisis or obiter at Strasbourg decisions, but there was a concurring opinion by 3 of the judges, starting on page 1083, who confined themselves essentially to the point that recruitment decisions were necessarily sovereign acts, so that they at least seem to have thought that what was said in paragraph 37 of the majority judgment was part of the basis for the decision.
Yes, or they wanted to remove any doubt as to whether that's the case. But what we do say on the stare decisis point is that in the 2022 decision in Nicolas Butet and UK, we see how the European Court has evolved its approach. That's same bundle, tab 34, page 1171, please. And in this case, a French national was employed as a security guard at the French embassy in London and sued for unfair dismissal. And the key passage is page 1187, paragraph 58. What one sees in the middle is the court saying a limitation of the right of access to a court will not be compatible with Article 6.1 if it does not pursue a legitimate aim and if there is not a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. And then when it comes to the operation of state immunity in employment disputes, once he's after referring to Fogarty, paragraph 33, when it comes to the operation of state immunity in employment disputes, the court has repeatedly held that measures taken by a high contracting party which reflect generally recognised rules of public international law on state immunity cannot in principle be regarded as imposing a disproportionate restriction. There's then a reference to Kudak, and that's consistent with what had gone before, we say, which is that paragraph 37 of Fogarty has, in terms of the European Court jurisprudence, fallen away, and the focus has been on paragraph 36 and Al-Adzani, paragraph 56. So back to our skeleton.
I mean, why does that show that paragraph 37 has fallen away? It's just talking about something different, isn't it?
Well, it's making the paragraph 36 point.
I agree it's making the paragraph 36 point, but it doesn't say anything about paragraph 37 having fallen away.
It doesn't, and but we say it's to be inferred.
It's talking about rules of public international law.
Yes,
So we understand the position where there are recognised rules of public and international law.
and I don't want to overstate my point. It's just that paragraph 37 appeared once and then not subsequently. That's as far as the point goes. And so when we
It appears subsequently in our jurisprudence in
Yes.
the Supreme Court, which we're bound by.
Well, not when it's OBTA, and when considering whether it's part of a coherent overall regime, including by reference to what the Court of Appeal had decided and the Secretary of State had submitted, we consider a relevant factor also to be that this is very different from what the position would be if the European Court kept saying Fogarty 37. Let's look at that again. Let's keep asking, is the forum state alone?
Can I just see how far your position goes? I entirely understand, I think, your submission that if the legitimate objective is compliance with international law, and we have to be careful, international law is quite a narrow concept by way of objective. If the objective is compliance, then you don't get anything out of international law as a justification for departure from Article 6 if there is no rule. That I understand. But do you say that that takes you straight to domestic justifications, which can have no regard to international practice, which falls short of a customary rule of international law? Or can international practice be capable of being a justification, short of a customary rule of international law, quite apart from domestic considerations as to what the justification might be?
I have to accept the latter because of the Supreme Court decision in General Dynamics.
Yes.
And so that may then frame grounds 1 and 2 in a relatively narrow context, but one has to address consecutively, we say, the legitimate aim of compliance with international law, which is what the judge against us has held is complied with based on Fogarty, etc. And that's grounds 1 and 2. And then separately, one gets to domestic policy objectives. But domestic policy objectives, I do accept, which take into account, at least, international practice. What I will say, by way of trailer on ground 3, is that if one has got past customary international law as justification in terms of a binding obligation, then there should be relatively limited space left in which domestic policy as a legitimate aim can proportionately operate by taking into account some limited extent of state
Why?
practice.
I mean, it may be quite a widespread practice, but just falls short of the necessary universality.
Well, and it's going to be a question of degree, and I accept that. But what I don't accept is that the first stage of the analysis is inevitably a formality, because when we get to consider domestic policy, we're just going to be able to choose from a menu of choices of what the UK, as in terms of its domestic policy, would like customary international law to become, and taking into account related concepts. And so I accept there is space for it to operate, and I mean, it may be that it's best if I come back to the extent of that space on ground 3. But what I do say is one can't just ignore what's gone before and say, well, why did we even ask about compliance with international law? Because we have an unfettered prerogative in terms of domestic policy to choose in which direction we want to lead. I mean, it's almost the forerunner point again, but in the context of ground 3 in domestic policy, that to what extent can domestic policy ride to the rescue and say it didn't really matter that there wasn't a customary international law rule, or that there was an existing rule, because it's both situations. There was an existing rule, but we prefer state practice to go further, and so we want to lead and later.
Well, I don't want to take you on to it, but just as a sort of categorization question, as I understand it, you say international law properly so described concerns obligations, and if there isn't an obligation under customary international law, that's that category which can't be used as a justification. And then the only other category which can be used is domestic policy, which can be informed by international practice falling short of a rule of customary international law, but as you'll go on to develop, only in have already partly developed, only in a rather limited, to a rather limited extent. Have I understood the way you put the points together?
Perfectly. And in terms of obligation, it's obligation or tenable view of obligation, because we say it's the Court of Appeal, with Lord Sumption not really saying anything different.
Yes, thank you.
So if one goes back to the skeleton, the seventh point may not take us far, because as has been identified, it's not just a question of Fogarty, it's a question of what Ben-Kabouche means, and it does in this jurisdiction recently refer to paragraph 37. I do want now to highlight, in terms of fair presentation, some of Venezuela's arguments on ground 1. So we can pick them up, please, in the core bundle tab 5, their skeleton, page 83.
Which paragraph in their skeleton?
Paragraph 31, please. They say we've viewed Lord Sumption's judgment in a myopic and untenable way, because we've said it's internally inconsistent. Then at paragraph 33, they set out the two key paragraphs which refer to Fogarty in that judgment, which I've already shown the court. Paragraph 33.2, they refer to the finding in Fogarty, and we do say that that has to be addressed with caution because of the point I made about it being a case on recruitment. Paragraph 34 says, it follows that, as found by the judge, Ben-Kabouche cannot possibly be authority for the proposition that a provision of the SAO will necessarily infringe unless the state shows it is obliged to grant the immunity by an established principle of CIL. And we do say that is so based upon paragraph 34 of Lord Sumption, subject to the tenable viewpoint. Paragraph 35 is where they address our point that the European Court has moved on. It says we're wrong because Fogarty was cited in Boutet. We've already just debated that point. And we address that in paragraph 19 of our supplemental skeleton at page 169. And that is the point I've already made in response to a question, that the language of paragraph 37 has not been repeated, but it doesn't go further than that. Back to Venezuela's skeleton, paragraph 36. They set out the scheme that they say follows, and this is the counterpoint to what I was just asked. They say that there are 3 stages. The first stage, if there's a relevant and identifiable rule. The second stage, if there's no such rule. And then the third stage is domestic policy. And we accept that in principle the third stage is a relevant inquiry, but I'm going to park that until ground of appeal 3. We take issue with the second stage for all the reasons I've already given. I do, though, if Ben-Kabouche is still open, want to go back into it just to see how Lord Sumption applied the test he had set out. And so that is, please, Authorities Bundle 2, tab 18, page 609. And here at paragraph 37, Lord Sumption comes back to what you may recall was the second consequence of the Secretary of State's submission, where they said that there was an absolute immunity onto which exceptions were grafted. He says the fundamental difference between the parties to this appeal concerns the starting point. On the footing that customary international law must require the UK to treat Libya and Sudan as immune, the Secretary of State submits that it does. This is because in his submission, state immunity is absolute unless the case is brought within an internationally recognised exception. This submission, if it is correct, would considerably broaden the scope of state immunity in customary international law by extending it to any group of claimants about whom there is a diversity of state practice. But in my view, it is not correct. The rule of customary international law is that a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority. So the starting point being taken is not absolute immunity, rather it's a rule that applies to sovereign acts, the restrictive doctrine.
And the restrictive doctrine being that you are not entitled to immunity.
Exactly. You are.
For commercial acts.
The positive rule is a rule of non-immunity from jurisdiction or adjudication in relation to non-sovereign acts.
And that's why you've got the important word only in that sentence. And that's the rule of customary international law that was under consideration in Beckenridge.
Exactly. And then Lord Sumption goes on to explain how one shouldn't be led away from that rule by the drafting technique of the State Immunity Act, which starts with, it would seem, an absolute immunity and then works back from there. And when it's said that immunity cannot be extended to any group of claimants about whom there was a diversity of practice, we do say in substance that that is Venezuela's case, that it can, by way of Fogarty, etc. So 38 and 39 deal with the drafting technique. Paragraph 52, please, on page 618. Lord Sumption goes on to say how the rule of customary international law, it's the point just made, is the rule that meets the necessary consensus of substantial uniformity. That's the secondly point that is in the middle of paragraph C there. And then one looks at how section 4.2 is addressed, please, which is starting on page 621. In relation to section 4.2 of the Act, at paragraph 62, just above letter G, Lord Sumption records how there is considerable diversity in the area, and that does, we say, start to look like Fogarty paragraph 37 territory. Likewise, if one looks at paragraph 66, please, on page 623, the United Kingdom is not unique in applying this principle. That's the principle in section 4.2 A and B. 7 other European countries are party to the European Convention on State Immunity. 6 other countries have enacted legislation containing provisions similar to section 4.2 of the UK Act. They're not identified, but one can infer that they're probably the same or similar to those countries that have legislation which also follows section 13.2a.
I mean, it's all a great forensic point, Mr. Lewis, but the fact of the matter is he's dealing with a case where there was a rule of customary international law that there was no immunity. Right?
That's what he goes on to find contrary to the Court of Appeal, and that's where they
So
do.
how does this help you?
Because all of the points that are made by Venezuela about a reasonable body of state practice should have led to the opposite outcome if, as they say, there is a two-stage test in Benkabush. But we say if it's understood the way it should be as a single test as follows from the Court of Appeal, with the fallback being only tenable view of obligations, then those materials were sufficient. I mean, test it this way. Why, based on Fogarty, could the Secretary of State not say there was no relevant identifiable rule in relation to immunity based on nationality and residence at the time of the employment contract? So the Secretary of State could have said we're within the range of possible rules scenario. And that wasn't sufficient. And that's where we say that the Court of Appeal...
well, there's no such thing as a range of possible rules in international law. I think that may be the danger of some sort of woolly terminology. International law, in the sense one's using it, means customary international law with obligations in what are a narrowly confined subset of international practice. International practice is a different thing from international law, but it doesn't follow that what the European Court was saying about international practice in Fogarty is not itself an independent reason which can justify departure from Article 6.
We don't accept that there is an intermediate position between compliance with international law and domestic policy taking account of international practice in a limited way, which we'll come on to. What we don't accept is that
that may be a categorisation distinction without a difference.
Well, it may be, because it may be that one should see that through the frame of domestic policy.
And it's incredibly dangerous to try and make categories out of a rule which says that you can derogate from Article 6 where there is a legitimate aim, it's proportionate to that legitimate aim, and you're not debasing the essential elements of the right. That's the rule we're looking at, not a whole bunch of categories that apply only here.
It is, and it may be that then there's an element of semantics, but we do say that in order to have a proper debate on proportionality, one must be clear on the legitimate aims. And so the relevant legitimate aims are here to be put under the headings compliance with international law and domestic policy.
You want the salami slicer, so you want to have a legitimate aim which is customary international law, and a completely separate, unrelated legitimate aim, which is international comity. And you say, ne'er the twain shall meet. But the fact of the matter is life is rather more overlapping than that. And trying to put everything into hermetically sealed boxes is what's led to a misunderstanding of Benkabush. I mean, you have to look at Benkabush as to what the judge decided.
We accept all that, and again, it may just be that if international conformity with international practice is put under the heading of a domestic policy being the legitimate aim, then there's no difference between us, and we get to that on ground 3. But we do say that in terms of the subject matter of grounds 1 and 2, if one brings in international practice there, then it risks making the arguments about compliance with an international obligation redundant.
But I mean,
that's because you defined the there as something which I'm not sure is where the judge defined it, as being rules of international law. You set up category 1 as being where there is a rule of customary international law, and you say it can't, where there isn't, therefore it can't comply with that. And international law has nothing to say about it. But you set up that category in order to say that it doesn't exist.
We set up that category, we say, consistently with the case law of the European Court. And then, while that category exists, we say it's not met by section 13.2a. And then when we get to ground 3 in general dynamics, we do deal with a different category. But we don't suggest that international practice, as I said, will be cast aside and ignored when we get to ground 3. Back to Venezuela's skeleton. Paragraph 37 makes the forerunner point, and we probably debated that sufficiently already. We reply to that in paragraph 20 of our supplemental skeleton, making my point, the answer I gave to a question that the Council of Europe members have so inhibited themselves subject to other ways of developing customary international law. And then the last point here is...
Sorry, it's my fault. By what means have they inhibited themselves from doing that?
So it's about the menu of possible international law options.
So are you saying the Strasbourg court has inhibited them from doing so by its rulings? Or is there something else that the Council of Europe has done which inhibits them from doing so?
Article 6, as interpreted by the Strasbourg court, has the effect of curtailing the ability of the states
I see. You simply say that's the effect of Article 6.
to get ahead of existing customary international law. And the last point to deal with on Venezuela's skeleton is the respondent's notice point. And we do say there's a disparity between the respondent's notice and Venezuela's skeleton on this. So the respondent's notice, which is core tab 3, page 29.
I mean, is it helpful to examine those kinds of disparities when they're not here, even to advance their respondents' notice?
Well,
I mean, I don't think we need to go into the minutiae of it. What's the point you're making?
the point is that the skeleton doesn't come up to what the respondent's notice says is the threshold.
What do you say on the substance of the point?
That the respondent's notice looks like it is the Court of Appeal threshold, which we say is how the Supreme Court should also be understood, even if they do not admit it's a different threshold. But then in the skeleton, paragraphs 38 to 40 just restate Fogarty and say the judge was correct. And we do say, based upon the limited support that Section 13.2a has in international practice, and we'll come on to that on ground two, there is no relevant obligation or tenable view thereof. Paragraph 40, what the respondent is saying is a slightly different point, where it says the question is not justiciable at the level of CIL at all, because injunctions, the question of whether the English law remedy of injunction should be available against states, and in particular anti-suits, is not justiciable. We don't accept that. The point appears to be that injunctions generally, but especially anti-suit injunctions, are parochial. And so it's not fair to expect Venezuela to establish a rule of customary international law that mandates immunity against them. As we will see when we come on to ground two now, we say there are sufficient comparators in the international law materials to be able to test the position on injunctions one way or the other. It's then said that injunctions are coercive measures of constraint. We're coming back to that on ground two. It's not properly part of the ground one analysis. Ground one is about what the test is. And so to put this another way, if we win on ground one and the test is on customary international law relatively strict, then we do say the burden is on Venezuela on ground two to show that there's some rule of customary international law relating to coercive measures of constraint, which mandates immunity from injunctions in general terms in the way that section 13.2a does. So unless there are any questions on ground one, those are my submissions, and I'll move to ground two.
Right. Now, you've, obviously I understand why, but you've spent more than a couple of hours, or just about a couple of hours on ground one. This case is listed for 2 full days, but broken up. I'm assuming you're not seeking to take advantage of 2 full days of argument.
No.
On your side. How long do you expect to be?
I was hoping to keep it within a day. If I wasn't trying to give a fair presentation, then I would certainly be able to do that.
Well,
Rounds 3 and 4.
I'm not rushing you, Mr. Lewis, at all. We've got the 3 days, but for the benefit of our diaries, will we be totally safe in saying we'll finish by lunchtime on Friday, whatever happens?
Yes, and I will endeavour to finish
Unless
tomorrow.
Ms. Shah is very long-winded.
I will endeavour to finish tomorrow, but please don't release Friday morning at the moment,
Yeah.
if I may put it like that.
Okay, well, tomorrow afternoon may be a little bit abbreviated in itself, because we may not get a clean start at 2 o'clock. I'll do my best. But, so don't try and squeeze it in. We want you to have the full opportunity to develop your submissions. I'm not trying to rush you.
Ground 2 is substantial, but grounds 3 and 4 will be quicker. While ground 3 is important, we will nonetheless be able to take it more quickly because we will have established a lot of the groundwork through grounds 1 and 2.
Very good. Round 2.
Ground 2 explores where does the test applicable from ground 1 lead on the facts of this case. And the judge found correctly, we say, that there was no rule of customary international law mandating immunity against injunctions relating to states' commercial acts. That is the first sentence of paragraph 115. And we also say there is no tenable view that customary international law mandates that immunity from injunctions. And so if you're with me on ground 1, we say it follows, applying Ben Kabouche, that section 13.2a cannot be justified by reference to customary international law. Our submissions on state practice are in the annex to our skeleton, in the table, which hopefully you've already seen, starting at core bundle tab 4, page 59. Where we have divided a number of states into 3 columns by reference to whether they A, prohibit, B, impliedly permit or have no prohibition, or C, permit the grant of personal injunctions against states that are unrelated to property. And we will revert to some of the detail as I make the parameters clearer on international law. So by contrast to our case, Venezuela's case is that injunctions are caught by an omnivorous rule that mandates state immunity from coercive measures of constraint which threaten, and that's a key word, threaten criminal and financial.
Can you say that again more slowly, please?
Yes. Venezuela's case is that injunctions are caught by an omnivorous rule that mandates state immunity from coercive measures of constraint which threaten criminal and financial sanctions. Why do they say that? It's because the restrictive doctrine is held by Ben Caboche to be the key baseline rule of customary international law. And that's the starting point aspect that we looked at. So Venezuela have to argue that the restrictive doctrine has no relevance here because section 13.2a, dealing with injunctive relief, is about enforcement. And that's in circumstances where state immunity approaches adjudication and enforcement on different bases. So there are,
That's what the judge said.
yes,
Yes.
as we see it, there are three overlapping issues here. Number one, the threshold issue is as to the nature of an injunction. And that issue arises for the purposes of its classification under customary international law. We say, at a general level, an injunction is a type of order, no more, no less. The second issue is as to the extent of the customary international law immunity from enforcement or execution. We say it's an immunity from execution that does not extend to orders or injunctions in personam unrelated to state property.
Sorry, it does not extend to what?
To orders or injunctions in personam unrelated to state property. As part of this second issue, we also say there is no distinct immunity from threats of criminal and or financial sanctions. The third issue is as to the extent of the customary international law immunity from jurisdiction, and whether that adjudicatory immunity, and so the restrictive doctrine, which provides a different answer depending upon private or sovereign acts, extends to the orders or remedies a court grants. So we do say on that the restrictive doctrine extends the type of order a court makes. And so injunctions in personam unrelated to state property in respect of a state's private acts are within the restrictive doctrine. So how does this fit in with the debate we've just had on ground one? If the court agrees with me on ground one, the relevant burden is on Venezuela to show there is a rule of customary international law, whether the general rule mandating immunity from enforcement or a specific rule relating to threats of criminal or financial sanctions, which mandates section 13.2a. The UK has done what's required by that international obligation. If the court is against me on ground one, then the burden is on me to show that the restrictive doctrine extends to injunctions in personam unrelated to state property. So the threshold issue, issue one, the nature of an injunction. Venezuela say an injunction is an inherently coercive measure because it's backed by penal contempt sanctions. And that link, whereby they say it's inherent in the injunction, they make more than once in their skeleton at paragraph 21.
I mean, you're concentrating on Venezuela's arguments, but should you not be concentrating on what the judge decided? This is an appeal from the judge, not from Venezuela.
Understood. I didn't want to come back to their case at the end.
I know,
to try
but
and
this
make
is an appeal from the judge. You haven't mentioned the
I will.
judge's judgment in ground one at all. I mean, it's helpful to me anyway. I mean,
I'm grateful.
It's a matter entirely for you, Mr. Lewis, but it's always helpful for me, for an advocate mounting an appeal, to say why the judge was wrong in what he actually said. And particularly because you may have sort of got your sights, if you like, aligned by reference to what counsel for Venezuela, not present, was going to be saying to us so as to knock down all his wonderful arguments, or her wonderful arguments. But actually, what I'm interested in, and I just put it out there, if you want to ignore it, you may, is why the judge was wrong on this point.
It only really features in the summation at paragraph 115 of the judgment after the judge has gone through some of the international law materials that we'll also look at. And that paragraph in itself has points with which I agree and those with which I disagree. But part of the challenge is that the case has moved on in that Venezuela's argument that there's an immunity from threats of criminal and financial sanctions is not exactly the same as the argument that they were running below.
Well,
and so I'll try and deal with...
To be perfectly honest, Venezuela's not here, apparently, to argue any new points. And the formal position would be that even its respondent's notice is not promoted unless counsel is here to put it forward. So we might look at it to Beni Esse because we might think it was a brilliant point and we should deal with it. But that would be a matter for us in trying to reach the right outcome. But I just want to be clear that you have the opportunity to make your submissions, not on why Venezuela paragraph 25 is a bad paragraph and all completely wrong, but why the judge, in what he said in the critical paragraphs of his judgment, was wrong and should be overturned.
In paragraph 115,
Yes.
What the judge says is that the restrictive doctrine is not in play in this area. I'm going to come back to that on issue 3.
Sorry, where are you reading?
Paragraph 115 on page 152, the core.
Okay, I'm looking at it in a different version. Let me just make sure that I have the same version as you're looking at. 115 in the core?
Paragraph 115.
Oh, which page?
Page 152.
Okay, thank you. Oh dear, I've unfortunately got a version of the judgment which has that at 114.
Oh, okay.
Very helpful.
It starts, there is no clear and settled view.
Yeah, no, I've got the paragraph, I just haven't got the... Okay,
I'll try and subtract 1.
Well, no, I mean, I've got to find out why I've got a different version. Because it's the version that was supplied to me by somebody. Anyway, you've got one that is headed judgment approved by the court, and I've got one headed
It does say subject to editorial corrections on mine.
Yes, 1, 2.
you see, mine is the published version. Comes off, imagine Bailey, could be the international, could be the National Archive.
We'll look into that as well.
No, this is not the version. You can't look at this one which says subject to editorial corrections.
It does also say on page 123 this judgment was handed down. But
Yes, it may have been approved by the court for handing down subject to editorial corrections. That has to come off in the final version. Let me look on the internet and see. Sorry, I don't want to delay you, but it is quite important that we do have the right version. Well, you carry on and we'll find it over the adjournment. Perhaps you can make sure you have the final published version on the National Archives website.
So the first sentence, there is no clear and settled view in customary international law regarding orders for injunctions and specific performance against states. We embrace that and we come back to that on issue 3. The second sentence says the restrictive doctrine is not in play in this area. We said that's wrong, and I'll come back to that as well. It says anti-suit injunctions are generally eschewed by civil jurisdictions. We said that's wrong. I'm going to come back to that. The point I'm dealing with at the moment is just in this sentence. There would seem to be a substantial uniformity that if a court does order a coercive measure against a state, any criminal or financial penalties attached are of no effect. And what I'm addressing here is that sentence and what's implicit therein, as developed by Venezuela, that there is a necessary marriage between the injunction and the sanctions for breach thereof.
Well, but sorry, that's 2 points. One, what's said, and what you say Venezuela say is implicit. Do you disagree with that sentence? Do you say that is wrong?
No, not in terms, but what we say is it doesn't have the impact here that it was given.
It doesn't have what?
The impact here that it was given, because what is embedded therein, when one then gets onto the conclusion in 116, is that injunctions are necessarily linked to sanctions for failure to comply, such that the immunity in relation to immunity from criminal and financial sanctions extends to preclude injunctions. And it's where Venezuela have adapted this to say the immunity is from threats of criminal or financial sanctions, to make the immunity wider, to make it go back, and to allow them to say that injunctions are threats of criminal or financial sanctions, and thereby covered. And so what I propose to do is to emphasize the distinction that we say exists between injunctions and subsequent and distinct questions as to their enforcement, which then engage questions about criminal or financial sanctions.
And put another way, you accept that there's substantial uniformity in customary international law against the imposition of sanctions, to use that shorthand. You say it doesn't follow that there's a rule of customary international law against the imposition of the injunction.
Exactly. And what we will see is that, for example, the UN Convention on State Immunity and Australia have just divided these two questions. And just said, on the one hand, one can have injunctions, on the other hand, one can't have criminal or financial sanctions or consequences beyond adverse inferences, is how it's effectively put by the UN Convention. And the theme that we say runs through grounds 2 and ground 3 is that English law has so wedded together injunctions and sanctions for non-compliance therewith that we cannot have a divorce under English law. We cannot keep those questions separate under English law, with the result that the limited immunity against criminal or financial sanctions covers English law injunctions.
I mean, what's the point of granting an injunction against a foreign state? You've already got a declaration that says they're bound by the contract.
We do have that declaration, and what we say is that there are a number of ways in which the injunction could be relevant beyond financial or criminal sanctions. It could be more likely to prompt compliance by Venezuela. The injunction will be stronger than the declaration to that extent, but I do say voluntary compliance with the terms of the injunction, because I don't stray into compliance by way
But you
of...
don't say there should be a penal notice or anything like that?
No.
You think that there's a stronger imperative to comply if you not only say this is what you are obliged to do, but you also say this is what we, the English court, are telling you to do.
Well, we do, because we say that the injunction is put in stronger terms than declaratory relief. And
Do you think that, I mean, let's assume that things had gone differently and Venezuela was simply not here. I mean, they're here, but they're here represented by people who are not, they're not talking to, so effectively for this purpose they're not here. So anything we say is, you say, going to make a difference, do you? I mean, it seems just incredibly unrealistic.
well, we do say that these points are flawed in two ways. The first is that if they were good, they would be an answer to every single anti-suit injunction, in that it could always be said, well, the Bill of Lading holders have brought proceedings in China contrary to the jurisdiction clause. We're going to give you here in the English court declaratory relief. But that's good enough, isn't it? We're not going to go further. We're not going to give any stronger imperative that they be restrained from pursuing any proceedings inconsistent with the jurisdiction clause. That's not the approach English court.
No, because you can apply sanctions to people in foreign
Frequently do.
states. That's
Because when
that's
they
the
bring their
difference.
assets into the jurisdiction, you can nab them.
But there's no debate at the stage of the injunction about whether those sanctions are actually going to happen in practice. And what we're having here is a debate about whether the injunction is going to make a difference.
It is
And
about
so
threats.
I mean, we don't accept that. And we do say when one is looking at the section 13.2a question in relation to injunctions as a question of principle, the probability that it's going to make a difference in terms of Venezuela's conduct is not relevant to the point of law. And so when we now distinguish between injunctions and their enforcement by way of criminal or financial sanctions, we do say in a way that's consistent with the state practice I'm going to show you. And the Australian Law Commission in Professor Crawford's report and the UN Convention on State Immunity have decided that it is worthwhile to have injunctions, notwithstanding that criminal or financial sanctions may not follow. So we don't accept that there's no debate here.
Okay, well, it was only an idle question, Mr. Lewis. I mean, you may be right, I'm sure. I mean,
We do have to come back to the question, though, in terms of your proposals as to in what way the section could be read down, if at all.
We will, yes, I can see that, because on ground 4, one of the possibilities is that clarification be made, that there be no penal notice. We say that's unnecessary, but it's one of the options. But as a starting point, we say it can be read down in a way that doesn't go against any other aspect of the statute, and indeed is consistent with two key aspects of the statute, namely the restrictive doctrine and the immunity from execution against property, only if it's non-sovereign. But I agree, and I will come back to that, if I may, on ground 4. So, as to the English law position on injunctions, which I can take fairly quickly, we set this out in our supplemental skeleton at paragraph 7 to 12. And we do say there's no difference of substance. This is the first point at paragraph 7, between injunctions and other orders. The CPR glossary defines injunction as a court order prohibiting a person from doing something or requiring a person to do something. That is admittedly generic, but it highlights the similarity in substance between injunctions and other orders. Here, Venezuela wished to rely upon G and how G says that the glossary in the CPR is a description but not a definition, because it could be true of many orders. But we say that shows how it's arbitrary to distinguish between injunctions on the one hand and other orders, such as orders to pay money. The key point is that we say this cannot be decisive as to how we classify injunctions as a matter of customary international law. We cannot take the view that English law has a particular aspect of injunctions and therefore they must be pigeonholed accordingly under customary international law. So if one looks at the passage in G on which...
So what is, I mean, this is aimed, is it, at the ground of appeal that says the judge was wrong to conclude that the immunity in respect of anti-suit injunctions was a matter concerning enforcement immunity in international law and was not governed by the restrictive doctrine applicable to adjudicative immunity, right?
Yes, that's granted.
And he says, as I recall his judgment, that he was bound by Supreme Court decisions to that effect, the House of Lords decisions to that effect. Now, what does the characterization of injunctions, how does that help you to overcome that?
Your Lordship correctly recalls that the judge starts with a number of cases that have put a framework on the Statutory Immunity Act and have just said sections 1 to 11 deal with the adjudicatory immunity, section 13(2) deals with enforcement jurisdiction.
That's the bit you say was wrong, right?
Yes.
I mean, I'm just dealing with your ground of appeal. It's your ground of
yes,
appeal.
I'm coming on to all those cases, if I may.
Yeah. But what's this? Yes, okay. I mean, I'm not trying to get in the way of the course of your argument, but I'm just slightly puzzled by why we need to know what an injunction is in English law for this argument, as stated in your ground of appeal.
Well,
because you said there were 3 issues, and to me those 3 issues didn't seem to add up to the ground of appeal, but I let you go on. But now we're getting into the weeds. I can't quite see which weeds we're going into.
I am preempting, and in a way that I would do even if Venezuela were here by counsel, their argument that there is this elision between injunctions and the sanctions, therefore, such that the coercive...
Where did the judge say that?
In paragraph 115, when the judge says there would seem to be a substantial uniformity that if a court does order a coercive measure against a state, any criminal or financial penalties attached are of no effect.
But that doesn't say what you just said. That just says exactly what he just said.
We had understood him to be saying, although it's not explicit, that this justifies section 13(2)(a), i.e. this immunity justifies a prohibition of injunctions, because injunctions are coercive measures with necessarily associated criminal or financial sanctions. And that's what that necessary association is the one I would seek to break.
Right. What he's actually talking about in this section is the enforcement jurisdiction in customary international law, and making a comparison of other nations.
Yes.
And simply concludes that, I think my paragraph 115, that the UK is not an outlier, and Article 6 is satisfied because Section 13 lies within the range of possible rules consistent with current international standards, the Fogarty test.
Yes.
So you say he was wrong. I mean, you know what? You do have to be tied back to your notice of appeal, which says that he was wrong to conclude that the immunity concerned enforcement immunity. The paragraphs you refer to are 91, 106, and 123 in addition to 115.
Yes. And our understanding of the judgment is that when dealing with the enforcement immunity generally, and within that context, the specific immunity from criminal or financial sanctions, the judge has concluded that the UK and the other states, on a basis that's sufficient for ground one purposes, are within that realm. And what I am seeking to show under ground two is that that was in error. And so I was going
What you're trying to show is in error, as I understood it, was in paragraph 91 of the judgment, which says the distinction is well accepted, and the clear dictum in Alcom shows that any submission that it's not about enforcement immunity is untenable.
Yes, that's part of it. I'm going to come on to those cases where they do no more than say, this is the general framework. They don't address this issue.
Why is an injunction which stops a state from doing what it wishes with its shows of action, namely a claim against the clubs, why is that not affecting its property?
We say that the distinction has to be made between the two separate immunities, so the immunity against adjudication and the immunity from execution against property. And what we don't accept is that even if the the claim, the underlying claim on the contract is treated as a shows in action, it is relevant property. But if it is, it will be non-sovereign property, and it will be non-sovereign property that should be within this jurisdiction. And so we'll get into, because the immunity from execution against property is itself not absolute, and it has a distinction which is not dissimilar to that under the restrictive doctrine, in that the distinction is made between sovereign and non-sovereign property. And so if one is to characterise the shows of action as property, and I may come back to that tomorrow if I may, we say that one would anyway end up by saying this is non-sovereign property, and that will feed through in the analysis of the various immunities that we've got to discuss.
Okay, well, I think we're going to have to leave it there, and we'll resume at 2 o'clock tomorrow, and that will give you an opportunity to consider some of the things we've discussed this morning. Thank you, Mr. Fist. 2 o'clock tomorrow.